Okay, so today we will talk about institution of criminal proceedings. So, who can institute criminal proceedings? You understand? Who can prosecute criminal proceedings, and who can institute criminal proceedings? Uh, one of the major distinctions between criminal matters and civil matters is that in civil matters, you talk about people doing their private rights and remedies. You understand? One person suing another for maybe torts or whatever, for defamation and all. But then when it comes to criminal matters, we're talking about the state, you understand, or the Federal Republic of Nigeria, you understand, depending on the nature of the offense. One thing with crime is that when a crime is committed, is deemed to have been committed against the state. You understand? It's an infraction against the state. You understand? It's an infraction against the state. So today we'll look at who can institute criminal matters. You understand? Who can institute criminal matters? Now it's relevant to know that a criminal matter must be instituted by the appropriate authority. You understand? If it's not instituted by the appropriate authority, then such trial or proceedings is a nullity. You understand? Is void. Is a nullity. So the person that can institute criminal proceedings in Nigeria include the Attorney General of the Federation or the Attorney General of the state, you understand, respectively. And then the police can also institute criminal proceedings against a person. We'll still get to see the nuances. Private persons as well, private persons in exceptional circumstances, you understand, subject to certain conditions, can also institute criminal proceedings against another. We'll also get to that later. And then special prosecutors. We also have special prosecutors. Special prosecutors can also institute criminal matter. Special prosecutors are just like the EFCC. Understand? And then private legal practitioners. That is like private legal practitioners are like individuals who are legal practitioners, who are barristers. Understand? So now we look at the Attorney General of the Federation or of the state. So the now the Attorney General is the chief legal officer of the federation or of the state. We have AG Federation, that is the Attorney General of the Federation, and we have AG State, that is the Attorney General of the state as well. You might see Section 150 and Section 195 for these provisions, respectively. Now, Office of the Attorney General of the Federation relates to federal offenses. I believe by now we should have known what are federal offenses and what is their state offenses. You understand? So, Office of the AG Federation relates to federal offenses, while Office of the Attorney General of the state relates to state offenses. You understand? So, as we know, the Attorney General of the state cannot prosecute an offender for a federal offense unless subject to those exceptions. Those exceptions as we know them. Those exceptions as we know them, such as when the federal legislation creating such an offense allows the state high court to try them. Understand? When that federal legislation is deemed to operate as a state law, when the fiat of the Attorney General of the Federation is obtained by the Attorney General of the state, and then within the circumstances stated in Section 286 1B of the Constitution of the Federal Republic of Nigeria. So in these four instances, the Attorney General of the state can then prosecute federal offenses. Understand? So it is relevant to know that the powers of the AG, the Attorney General, whether of the Federation or of the state, has has powers. Has a lot of powers, or let me say, it has three major powers. It has three major powers. If you look at Section 174, subsection 1 for the federal AG, and then Section 211, subsection 1 for the state AG, you see the three major powers. You can institute action against any person in any court of law except the court martial. It can actually take over a case that is instituted by any person against another person, and then it can also enter what we call nolo prosecute. Do not prosecute. That is to terminate a particular proceedings before judgment is given. So now these powers of the AG is delegable. This power is delegable. Now, what we say is delegable simply means that the AG can exercise this power either in person or through the officers in his department. You understand? So he can delegate any of those his powers to the officers in his department. You understand? He can delegate the powers to instance, for instance, to a state council or maybe to the DPP or to anybody, you understand? So those powers can be exercised by him either personally or through officers in his department by way of delegation. You might see the case of a controller of prisons against Adekanye. So now we look at the powers of the AG. We analyze the powers of the AG one by one. So if you look at section 174, subsection 1, paragraph A, and 211, subsection 1, paragraph A, you will notice that the AG has powers. The AG has power to institute and undertake criminal proceedings in any court other than a court martial. You understand? So the AG can institute or can undertake criminal proceedings against any person. You understand? Against any person in Nigeria, against any person or any authority, anybody at all. You understand? It could be against a company, it could be against a natural person. You know, the AG can institute criminal action against any person at all in Nigeria, except in a court martial. The AG cannot institute an action in a court martial. In a court martial for military personnel, that is servicemen. And then they say the power of the AG to prosecute cannot be whittled down by an injunctive relief. Now, what this is saying is that, for instance, like we said before, the AG has power to institute action against any person. Anybody who has committed an offense, the Attorney General can institute action against that person. And then now, the court cannot stop the Attorney General by way of an injunction from instituting an action. It's not possible for the court to say we have passed another perpetual injunction or another interlocutory injunction, whatever injunction at all, bearing the AG from instituting an action. It's not possible. You understand? The judiciary cannot take such a step. You understand? Is a legal anomaly. It's a judicial sacrilege for the judiciary to attempt to do such a thing. It's not within the contemplation of the Constitution that the powers of the AG to institute action against anybody can be curtailed by the courts. It is at the discretion of the AG to institute an action against a person. It cannot be curtailed by the court. So the AG in instituting actions against person must have regard. See, one thing about the Attorney General is that the power is massive. The powers that are vested in the Attorney General is very massive. The legal power. That is why they call him the chief legal officer. He has a lot of powers. His powers are monumental. Understand? But then in the exercise of these his powers, he must have regards to the course of justice. So, for instance, in instituting an action against a person, he must make sure that it does not amount to abuse of court process. It doesn't amount to abuse of court process. So, this particular power, which is tied to section 174 sub 1A and 211 sub 1A, that is the power to institute an action against any person at all in any court in Nigeria except a court martial. Now, this power can be exercised by the AG himself personally. And then you might ask, what if the AG is not in office? Now, it is possible that the AG might not be in office, maybe for one reason or the other. Now, can the officers in his department institute an action? When the AG is not incumbent, like when the AG is not in office, can the officers in his department, such as the DPP or other state councils, can they institute an action against any person, or must they wait for the AG to come back? Now, in this case, officers in his department can institute the action. They can institute a criminal action against any person, even if the Attorney General is not in office. Even if he's not in office, they can do that. And then the second power of the Attorney General is the power to take over and continue a criminal proceedings already instituted by any authority or any person. Now, if a person have already instituted a criminal case, or anybody has already instituted a criminal case, the AG can be like, I want to take over this case, maybe for whatever reason best known to him. It could be in public interest, in the interest of justice, or maybe a petition was written to him, you understand? So he can decide to take over a particular case, you understand? So maybe for instance, the EFCC or the ICPC or NAFDAC may institute an action against a person, and then the AG can just come and take over such a case and take over the case, the power of the AG to take over a case is so strong, you understand? You cannot question the AG when he decides to take over a case. The powers of the AG, like I said before, is very massive, is monumental. It's not subject to any form of curtailment by the court. So, but this power of the AG to take over a case is rarely used. You understand? The AG rarely takes over cases. He usually does that where, for instance, a petition has been made to him. A petition has been made to him that the person prosecuting the case, like the prosecuting authority, for instance, the EFCC is biased in the case, and then the AG can then decide to take over the matter. Or it could be lack of diligent prosecution. Maybe a particular state council is prosecuting a case on murder and then he doesn't even come to court often. The AG can decide to just take over the case, or maybe on the grounds of fairness and justice. In the interest of justice, the AG can decide to take over a case where he believes that taking over such case will be in the interest of justice. He can take over the case. And then it's relevant to note that this power of taking over a case, it can also be exercised even if the AG is not in office. You might ask yourself how. Yes, it's possible. Maybe the EFCC has instituted a case and then the EFCC is not serious, or the EFCC is being biased in prosecuting that person for money laundering or whatever. If there is no incumbent AG in office, the officers in his department, that is state councils, a senior state council can say, I want to take over this case on behalf of the AG. Even if there's no AG in seat, he can decide to take over the case. Understand? So that's why they say the powers of the AG can be exercised either by him or through officers in his department, although it's usually by way of his delegation. But if the AG is not in office, the question now is who is going to make the delegation. They cannot say, because the AG is not in office again, because maybe he was removed by the president or for whatever reason, or he's dead, and then an appointment has not yet been made. They will not say, we have to wait until somebody is appointed, the Attorney General, and they will not seek his delegation. No, they can on their own institute an action against a person under paragraph A, and then they can on their own as well take over a case, for the purpose of or for the interest of justice. But when we get to the last power under paragraph C, that is to enter a nolle prosequi, we will know if that is still the case or not. So now the last power of the AG is the power to discontinue criminal proceedings in any court before judgment is given. Now the AG has power to discontinue any criminal proceedings, you understand? So if there's any criminal proceeding instituted in courts in Nigeria, you understand? Maybe the EFCC has already instituted a case, or any person has instituted a case, or any private prosecutor, that is the legal practitioner, has instituted a case against another person, any criminal trial at all, the AG can just come and say, look, stop prosecuting this defendant. Enough is enough. This case, should be terminated. Don't prosecute him again. Understand? That is what they call nolo prosequi. Do not discharge. Well, I think this is more like the most critical power of the AG. Understand? It's more like the most resounding power of the AG. Understand? So the AG can just come and terminate a proceeding, and the person is automatically deemed discharged. Understand? So the AG has power to not just to institute action, to take over action that has already been instituted, but also to discontinue such action, even if he was not the one that instituted the action. And one thing you have to understand is that the AG does not need the leave of the court. He doesn't need the permission of the court, you understand? He doesn't need to come to court and give reasons, you understand? The AG is not accountable to the court, you understand? The AG acts on his own frolic when it has to do with entering of nolo prosequi. Although the law requires that, yes, he still have to he still needs to have regard, to the interest of justice, and all that. But it does not mean the court can control him. The court cannot refuse a nolle prosequi entered by the AG. It's not within the contemplation of the Constitution. Such is a legal anomaly. It's a judicial sacrilege for the court to refuse a nolle prosequi entered by the AG. So the AG doesn't even need to give reasons. Zemo against AG Bende state against Lorry, and all that. So the AG doesn't need to give reasons. Understand? The only condition is just that the AG has to do this before judgment is given. Understand? Because once judgment is given, such a case can no longer be discontinued by the AG. Understand? So he just have to make sure that he discontinues the case before judgment is given. He can't come on appeal to discontinue a case. It's not possible. He must do that during the trial. So now we go to the mode of entering nolle prosequi. How can the AG enter a nolle prosequi, or how can nolle prosequi be entered? Now, nolle prosequi can be entered either by the AG himself, personally, or through the law officers in his department by way of delegation. So that is exactly what we have been talking about. That these powers, the power under paragraph A, under paragraph B, under paragraph C, it can be exercised by the AG himself or through the officers in his department by way of delegation. You understand? So now, when the AG is entering a nolle prosequi, now we are concerned with the power in paragraph C, that is nolle prosequi. So now, when the Attorney General is entering a nolle prosequi personally, you have to take notice of this area. When the Attorney General is entering a nolle prosequi personally, he can do so. He can just come to court and enter it orally. You understand? He can just come to court and enter it orally. He can just come to court and enter it orally. But then, where he delegates another person, that is, for instance, an officer in his department, you understand, where he delegates another person, such as an officer in his department, to enter the nolle prosequi, it must be in writing. You understand? So that's the exercise of the nolle prosequi must be in writing. In other words, that officer that he delegated will have to come to court and give a notice in writing, that on behalf of the AG, that they are entering a nolle prosequi for this particular case to be discontinued. You understand? Now, this is the position in Agja and in Kano. You understand? This is the position in Agja and in Kano. You can also see the case of Chukura against State. You understand? Now, this is the position in Agja and ACJA Kano. But if you look at ACJA Lagos, there was no particular mode. You understand? There was no particular mode in which nolle prosequi may be entered. You understand? In ACJA Lagos, if you look at section 71, it just said that a nolle prosequi might be entered by the AG, but it did not state any it doesn't give any particular mode. That of Agja and ACJA Kano was precise in the sense that the AG can do so orally in court, but where he's delegating it, then it has to be the exercise of the power by the person who is delegated has to be in writing, something like that. But then the ACJA Lagos is silent on the mode of exercise of a nolle prosequi. You understand? So the implication of this silence is that since the ACJA Lagos does not say whether it has to be in writing or orally, the implication now is that where such power is delegated, then it may validly be exercised, maybe orally or in writing by the law officer in his department. You understand? Now, this is the position, and this is actually how we were taught in Lagos campus. Although I spoke to one of my friends, I don't know the campus he was. He wasn't, and then he was emphasizing on this case of Chukura against the state, and then he was saying Chukura against the state is of universal application, that it applies in all jurisdictions. But I don't agree with him actually, because this is actually the manner we were taught in Lagos campus. So now we might ask ourselves, can the power to discontinue criminal proceedings be executed without an incumbent AG? An incumbent AG. Yeah, we have said, for instance, that the power of the AG to institute criminal action can be exercised by officers in his department, even if there is no incumbent AG. And then we have also said that the power of the AG to take over a case already instituted by someone else can also be exercised by officers in his department, even if there is no incumbent AG. Now, when it has to do with nolle prosequi, the powers under paragraph C, the law is that such power cannot be exercised unless there is an incumbent AG. In other words, where there is no AG in office, nolle prosequi cannot be exercised. Understand? The case of AG Kaduna State against Hassan is a locus classicus for this principle, and the rationale or the reason d'etat behind this principle is because the power is solely tied to the person and not necessarily the office. You understand? So this power of nolle prosequi is tied to the person of the AG. He has to be around, he has to be in office. There must be physically somebody who is the AG before the power of nolle prosequi can be exercised. Whether by him or on his behalf. Understand? So if there is no incumbent AG, nolle prosequi cannot be exercised by the officers in his department. And then now, what is the effect of a nolle prosequi when entered? A nolle prosequi operates only as a discharge. I know by now you should know the distinction between discharge and acquittal. When a person is discharged, I think I've said this before, like in a very basic example, when a person is discharged, they're just telling you, okay, go. For now, just go. Maybe if there's any stronger evidence against you, we'll bring you back to court. But for now, just go. You are free for now. That is what a discharge looks like. But when a person is discharged and acquitted, it simply means that the person has been found not guilty of that offense. The person is totally innocent. You understand? and then the person has been let go, and he cannot be brought to court again on the same facts and on the same grounds, you understand, for which he was brought to court before. So when a nolle prosequi is entered on behalf of a person, the person is merely discharged. You understand? That means he can still be brought to court again, on the same charge. CAG Lagos State against Clark. And then where the defendant is in prison, he has to be released. He has to be released. And if he has entered any recognizance to be of good conduct, he has to also be discharged from such a recognizance. And then we talk about the power of withdrawal. Now, there's something that is quite similar to nolle prosequi. There's something similar to nolle prosequi, but it's not nolle prosequi. And now this is the power of withdrawal. You understand? Power of withdrawal. Now, there's something called withdrawal. Now, it's possible that the prosecution has instituted an action. A matter is already in court, and the person is being prosecuted for a crime. It's possible that the person is being prosecuted for a crime, but then at the end of the whole day, the prosecution, it could be probably with the consent of, it could be on the authority of the AG. You understand? It could be on the authority of the AG. Maybe the prosecution will get maybe a notice from the AG, say, please withdraw that case from that. Let's just stop prosecuting this guy. Let's withdraw the case. Now, withdrawal is not the same thing as not the prosecute. It's somehow similar, but it's not. But it's mainly the prosecution. You understand? It's mainly the prosecution. It's mainly the prosecution that decides to withdraw a case. That is, for instance, state counsel. State counsel who is representing the AG in court. He can just decide that, this case I'm prosecuting, maybe I don't have enough evidence, or maybe there's no need to continue with this case, and then he will just decide to withdraw it. You understand? It's mainly the prosecution. When we talk about the prosecution, I know oftentimes what comes to our mind is the Attorney General, who represents the state or the Federal Republic of Nigeria. But the Attorney General, like I said before, doesn't usually come to court. Yes, it doesn't come to court. It's usually presented by state counsels, senior state counsels, or principal state counsels. Understand? So these state counsels in courts that are prosecuting the case can decide to withdraw that case. Understand? They can decide to withdraw that case either with the consent of the court or on the authority of the AG. You understand? They can decide to withdraw the case, or they can decide to withdraw a charge. You understand? It's also possible to withdraw a particular charge. You understand? That is one major distinction between that is one major distinction between a nolle prosequi and withdrawal. You understand? Nolle prosequi oftentimes is that you are withdrawing the whole case. You understand? But in the case of withdrawal, the prosecution can just decide to withdraw a particular charge, or let me call it count, so it's not going to confuse you. But although sometimes you can be used interchangeably, charge one or count one, depending on the court you are prosecuting. Understand? So the prosecution can decide to withdraw count one, or maybe withdraw count one to count three, and then leave count four, count five, and all that. So it's possible for a case to be withdrawn. It's also possible for a particular count inside of the charge sheet to be withdrawn. So now this is similar to a nolle prosequi, but it's not a nolle prosequi. And then now we have to understand the effect of the withdrawal of a particular case. Now, when a case is withdrawn, what is the effect? You understand? What is the effect? Now, so where a case against a person, or where a charge, like let me say for instance, when I'm using charge now, I'm talking about the whole case. Now, where a charge or where a case is withdrawn before a defendant opens his defense, it is a mere discharge. You understand? So if, for instance, the prosecution decides to withdraw a case, he's no longer prosecuting this defendant, and he withdraws that case before the defendant opens his defense, it is a mere discharge. You understand? It operates merely as discharging the defendant. But if the prosecution withdraws the case against the defendant after the defendant has opened his defense, then such withdrawal is going to operate as an acquittal. You understand? So we now see the differences between withdrawal and nolle prosequi. Nolle prosequi at all times, once it is orchestrated, it operates as a discharge. For instance, usually in court, it's the prosecution that starts first. He starts first, calls his witnesses, they tender document and all, and then later the defense will now come to give his defense. So now, if maybe the defense, if maybe when I say the defense, I mean the defense counsel, the defendant counsel, if the defendant counsel has already opened his case, he has started calling evidence in favor of the defendant, showing how the defendant is innocent and all. And if the prosecution did not withdraw the case since, but he waited until the defendant counsel, started calling evidence, giving evidence, showing the innocence of the defendant, or whatever evidence is given to rebut the prosecution's case. Now, if the prosecution, after the defendant counsel has done this, he decides to withdraw the case, it operates as an acquittal. You understand? It will now operate as an acquittal. Or if before the defendant counsel comes to start giving evidence in favor of his client, and then the prosecution before that time withdraws the case, it will operate merely as a discharge, meaning that defendant may still be called upon later on to be tried again on the said charge against him. So now we see the differences between nolle prosequi and withdrawal. In the case of nolle prosequi, like we said before, you don't need leave of the court, you don't need to explain to the court, whatever. But in the case of withdrawal, you need leave of the court. Understand? A prosecution cannot withdraw a case or maybe a count in a charge without the leave of the court. And then he has to also give reasons why he's withdrawing the case or why he's withdrawing a particular count inside of the charge sheet. You understand? And then sometimes the court may award cost. Cost is usually awarded by the court. Cost is usually awarded by the court. If, for instance, now the prosecution now withdraws the case, most times cases don't just happen in one day. It will start today, the court will adjourn. Before 1 year has already passed, and then after 1 year, you're withdrawing the case or you're withdrawing the charge against the defendant. The court can award cost against you. It's a prosecution, or you have to pay some money to the defendant for wasting his time and all the expenses he has incurred for this whole trial, that kind of thing. So these are other differences as well. Nolle prosequi is usually in whole, or withdrawal may be partial, in the sense that you can just withdraw a count in a charge, or you can withdraw a charge, and then during in the case of withdrawal, the court has powers. The court has powers to give directions in withdrawal. But like we said, in nolle prosequi, the court does not have any power. It's the AG that decides if he wants to discontinue a case or not. But in the case of withdrawal, the court can even say, okay, it's fine. Even if the defendant has not opened his defense and you want to withdraw this case, let it operate as an acquittal. You understand? The court has power to make such an order. Let it operate as an acquittal. The court can do that. You understand? And then, in nolle prosequi, we say that you must have an incumbent AG. In the case of nolle prosequi, that you cannot enter nolle when there is no incumbent AG. But in the case of withdrawal, the prosecution, like I told you, is usually the state counsel. So that state counsel or the principal counsel can withdraw a particular case or charge against the defendant, even if there is no incumbent AG in power. And then now we look at the second kind of persons who can institute criminal proceedings, and that is the police. Now, I want you people to understand something clearly. You understand? I want people to understand something clearly. Now, they say, subject to the powers of the AG, police officers who are legal practitioners can institute criminal proceedings in any court of law, whether or not the information is laid on his name. So now what this section is trying to say is that provided the police officer is a legal practitioner, he's a lawyer and he has been called to bar, he can prosecute or he can institute any criminal matter in any court of law. Understand? Whether state high court, when he goes to appeal, he will still be prosecuting the case. When we talk about this institute, at the same time, we need to also consider the word prosecute, because whoever institutes a criminal action is the one prosecuting it. You understand? So police officers can institute and prosecute criminal actions in any court at all in Nigeria, provided that police officer is a legal practitioner. So he can institute an action at the magistrate court or the High Court of Lagos State, and when the matter goes on appeal, he will still be the one to be prosecuting the matter. Even when it gets to Supreme Court, he will still be the one to be prosecuting the matter, provided he's a legal practitioner. Now, if a police officer is not a legal practitioner, whether or not he can prosecute or institute a criminal action will depend on the relevant criminal procedural law existing in that state or in that jurisdiction in which he wants to institute or prosecute the criminal matter. If a police officer is not a legal practitioner, whether or not he can institute and prosecute that particular action in any court, will depend on the criminal procedural law of that particular state or that particular jurisdiction. Now, we give examples of the criminal procedural laws. Examples now include, for instance, in ACJL Lagos, which is applicable in all southern states in Nigeria for the purpose of your bar finals. They say if a police officer is not a legal practitioner, he can only prosecute in magistrate courts. You understand? He can only prosecute in magistrate courts. So this is the position of law in ACJL Lagos and South applicable. And then now, if he's in Kano, that is Kano and North as a whole, if the police officer is not a legal practitioner, he can only prosecute in magistrate courts. So the implication is that if he's not a legal practitioner, he cannot prosecute in state high court. If the matter goes on appeal, he cannot be the prosecuting party. You understand? And then in the federal high court, police officers cannot prosecute at all. You understand? Section 58 of the Federal High Court Act listed people that can prosecute criminal matters in the Federal High Court, and it did not in any way include police officers. You understand? It did not include police officers. So now we look at the High Court of the FCT. Now, in the High Court of the FCT, police officers who are not legal practitioners can prosecute in the High Court of the FCT. You understand? So I want you to understand this principle very, very well. You need to understand it part by parts. Generally, if a police officer is a legal practitioner, he can prosecute in any court at all. If he's not a legal practitioner, then whether or not he can prosecute in all the courts in that state and jurisdiction will depend on the provisions of law in that state and in that jurisdiction. ACJL Lagos is saying unless he's a legal practitioner, he can only prosecute in magistrate court. Kano adopted the same position. Unless he's a legal practitioner, he can only prosecute in magistrate court. Federal High Court says no. It says it does not even include police officers. Police officers cannot prosecute at all. They are not part of the prosecutorial authorities at all. They are not included. You understand? And then in the High Court of the FCT, you see, non-lawyer police officer, that is whether or not the police officer is a legal practitioner, he can prosecute in the High Court of the FCT. And then I want you to understand that under the Police Act 2004, there is this particular section, that is the old Police Act, this particular section, section 23. That section did not distinguish police officers who are legal practitioners and police officers who are not legal practitioners. You understand? So section 23 of the defunct Police Act did not distinguish police officers who are legal practitioners and police officers who are not legal practitioners. That was why the court in Olusegun against COP and George Osahon against FRON held that police officers can prosecute and institute criminal actions in any court. You understand? So if we go by these two cases now, you can ask yourself if these cases. Now you can ask yourself now, these cases, they are good authorities for which courts? These two cases only apply in relation to High Court of the FCT. So apart from the High Court of the FCT, these two cases are not valid authority. You understand? Because the position of law has changed now. The Police Act of 2020 now distinguished under section 66 subsection 1 and 2 and 66 subsection 2 of police officers who are legal practitioners and police officers who are not legal practitioners. So the only place where you see police officers who are not legal practitioners and are allowed to prosecute cases are in the High Court of the FCT. You understand? So the case of Olusegun and COP and the case of George Osahon against FRN does not apply again in Nigeria except in the High Court of the FCT. And then we look at private persons. Now, private persons are just like me and you understand? Private individuals who are not legal practitioners. That's private persons who are not legal practitioners. Yes, they can also institute criminal actions. Private person, that is the market woman on the streets, and the man who is selling his electronics at the Onitsha market. Yes, he can institute criminal action. He can institute and prosecute criminal actions. You understand? He can institute and prosecute criminal actions. Now, how does he do this? He can do this by laying a complaint to the court. A particular example of a case where a private person instituted and prosecuted a criminal matter against another private person is the case of Oniyide against Oniyide. I think that was the case of assault. A husband grievously assaulted his wife, and the wife took out a complaint and then instituted a criminal action against him. You understand? So it's possible, and the wife instituted and also prosecuted the case. So it's possible, you understand? But there are certain conditions. There are certain conditions that must be existing. Before a private person can institute and prosecute criminal actions against another private person. Now, one of them is, the private person must file an information. Private person has to file an information, and then the information must be endorsed by a law officer that he has seen such information and declined to prosecute at the public instance. Understand? So the private person is to file an information, and then there must be an endorsement, that is in writing, to say that by a law officer, because the private person will take the information to a law officer and say, look, I want to prosecute this matter myself, and then the law officer should endorse that he has seen the information and he refused to prosecute same. You understand? So in other words, he's saying, I'm a private person, carry your wahala and go and do it yourself. Under the ACGL Lagos, that information may be brought to either a law officer or to the Attorney General of Lagos State. You understand? So he can also on his own endorse that he saw the matter and he didn't want to prosecute it himself. So the private person should go and do it himself. And then now that private person has to enter a recognizance or execute a bond, you understand, in the sum prescribed by statute, e.g. 50,000 naira, as provided in ACGL Lagos. Now, the essence of this bond or recognizance is more like, he's making a kind of, what will I call it? He's making a kind of saying, look, I'm going to do this thing very well, you understand? So he will have to enter a bond or a recognizance to prosecute diligently to the legal conclusion of the case. Now, when we talk about recognizance, I think the best description I can give for recognizance is, for instance, somebody is in need of bail. He wants to be bailed. He has been arrested by the police, and then he wants bail. He wants to get bail for himself. Oftentimes, maybe all these cultists and gangsters, they will enter a recognizance to be of good conduct. They will sign something on paper and say, hey, therefore, from now on, I'll be of good conduct as a condition for me to enter into this bail. You understand? That's what they call recognizance. And then to execute a bond is more like a money. You have to pay money and all that. So in this case now, the private person will either enter recognizance or execute a bond, monetarily, that he's going to prosecute the case diligently to the legal conclusion of the case. He's not going to get to one certain point now and then you say he's not prosecuting again. And then he's going to provide a surety that is known to the chief registrar. You understand? So he has to provide a surety. He has to provide a surety. Usually someone of a good standing in the society. And then lastly, he has to pay any relevant deposit and costs as may be fixed by the court. When you want to prosecute an action, there are certain, even in civil actions, there are certain payments you pay the registrar, filing, this one, all those deposit and costs. He has to still pay them. He has to pay them. Now, if you go to the handbook, if you go to the handbook, criminal litigation handbook, you will notice that under this topic, exceptions and limitations were actually stated. You understand? So it is not in all offenses that the private persons can prosecute. There are certain offenses that the private persons cannot prosecute, and then there are also limitations. There are limitations on the powers of a private person to prosecute. For instance, it is possible that the law creating that offense states the class of persons that can prosecute that offense. You understand? So if, for instance, the law on adultery under the penal code has stated that only the Attorney General of the state or of the federation can prosecute the case of adultery, a private person cannot now go to file an information in order to institute and prosecute the case of adultery. You understand? So also, when it has to do with offenses of official corruption against a judicial officer, the information must be signed by the AG. You understand? So the AG has to sign that information. If the AG does not sign the information, such action cannot be commenced against such judicial officer. And then when it has to do with the offense of sedition, when it has to do with the offense of sedition, we should know what is sedition. When you're making any publication that is bringing the government to a bad light, you're painting a negative or terrible picture of the government, in order to spoil the mind of the people against the government of the day. That is sedition. You're being seditious. Understand? So when a person has committed the offense of sedition and then a private individual wants to prosecute that case, consent of the AG must be obtained. Understand? And then it's relevant to know that when a private person is prosecuting an action, if a private person, for instance, is prosecuting an action, the case name, on the cost list, the case name is not State against Johnson. If a private person, for instance, is prosecuting an action, it will still be on his name. You understand? So if your name, for instance, is O.D. Michael, and the person you're prosecuting the case against is Okafor, it's going to be O.D. Michael against Okafor. That is why that first case I showed you, the case of Oniyide against Oniyide, I told you it was a family case. A wife instituted and prosecuted a criminal action against the husband for grievous assault. You understand? So the name doesn't change. The designation does not change. It doesn't change from state. It doesn't change to state against Oniyide. It's still going to be Oniyide against Oniyide. And then now we can also have another class of persons who can institute criminal actions are private legal practitioners. You understand? If you are caught to bar tomorrow, and then you see someone commit a crime, you can on your own decide to institute that criminal matter and also prosecute it. You understand? So now you can do this either with the fiat of the AG or without the fiat of the AG. You can decide to do this. Either you can seek the fiat of the AG to prosecute it, or you can prosecute it without the fiat of the AG. So now when a fiat is granted, a fiat remains in force until an appeal is terminated. Once the AG grants you a fiat, that fiat is going to remain in force until an appeal is terminated. And then we talk about the last classes of persons who can institute criminal action. The last classes of persons that can institute criminal actions are people we call special prosecutors. Special prosecutors. An example of special prosecutors are legal officers. Like, when you go to some places, they will say, oh, this is the legal department. Every institution most time will have legal department. So if the EFCC, for instance, the EFCC has legal department. Now, in the legal department, you see lawyers who institute actions on behalf of the EFCC. Understand? If you also check the Nigerian Drug Law Enforcement Agents, they also have legal department. That is where you see a team of lawyers instituting actions on their behalf. And then some legislations. There are some laws or some legislations that recognizes lay persons, that is, ordinary individuals who are not legal practitioners. That particular legislation recognizes them as special prosecutors. For instance, if you look at Section 66 of the Factories Act, it's an inspector of factories, can prosecute offenses arising from the factory. So, for instance, every company or any factory might have who they call inspector, who comes to check how the factory is being run. So where maybe an offense is committed in the factory, he can personally institute and prosecute the action. So now we go to the concept of limitation of time to commence criminal proceeding. Ordinarily there is this saying that a crime does not, it doesn't sour. There's something they say in pidgin English: crime not the sour. You understand? So a crime does not abate. If a person commits a crime today, you can bring that person to action 90 years later. Provided there are sufficient evidence to prove the case beyond reasonable doubt. That's the most important factor. So a crime does not abate, provided there is sufficient evidence to prove the case. You can bring the person to book. You can institute an action against the person at any time. See Ochu against FRN. But however, there are exceptions. Like we always say, to every general rule, there's an exception. Non est regular quin falit. You understand? So to every general rule in law, there's an exception. So now there are some offenses. There are certain offenses that there's a limitation period. There's a limitation period. So you have to prosecute that person within that period. If you don't prosecute that person within that period, then that crime, that offense has become a statute barred. You can no longer prosecute the person. So an example are sexual offenses against minors under the age of 13 or above the age of 13, but less than 16, including a sexual violation of idiots and imbeciles. You understand? So when a person violates a girl who is under the age of 13, or maybe the girl is above 13 but less than 16, or the girl is an idiot or imbecile, that is someone who is mentally incapable of doing certain things, mentally altered. Such persons, the time frame for prosecution is 2 months. You understand? So an action has to be brought against the defendant within 2 months. I think one of the rationale behind this is that because the person is an infant, is a minor. So because once it's like 6 years, 7 years, the person might not have complete recollection of who did what and how it happened. So it's very good that the infant who is under the age of 13, should immediately recognize the perpetrator of such a heinous and a repugnant act within that time. So it shouldn't be so extended period of time to ensure that every evidence is still intact. You understand? And then proceedings under the Custom and Excise Management Act is 7 years. You understand? So where an offense is committed under the Custom and Excise Management Act, it has to be instituted within 7 years. After then, it is statute barred. And then military offenses as well. If a person commits an offense while he's in service and then subsequently retires, the person should be brought to court within 3 months of his leaving military service. You understand? Otherwise, after 3 months, the offense becomes statute barred. But there's an exception. Certain military offenses are never statute barred. They can be brought at any time, such as the offense of desertion. When you desert from the military. Mutiny, you understand? Mutiny. Failure to suppress mutiny. When we talk about mutiny, we're talking about uprising. You are trying to lead an uprising in the military against your boss and those of high authority. Those offenses are, they are never statute barred. Then civil offenses committed outside of Nigeria. When you commit a civil offense outside of Nigeria, they are also never statute barred. And then the offense of treason and treasonable felony should be prosecuted against a person within 2 years. Otherwise, it's statute barred. And then the offense of sedition should be instituted against the offender within 6 months. Otherwise, it is statute barred. However, as a matter of an exception, it's relevant to know that why all these offenses have time limitations, the conspiracy to commit those offenses, you understand? The offense of conspiracy, the offense like conspiracy is an offense. We did something like an inchoate offense or preliminary offense in criminal law in the university. So conspiracy is one example of inchoate or preliminary offense. Now, when a person commits the offense of conspiracy, that is forming the intention to commit the actual offense, there is no time limitation for conspiracy. You understand? So if you conspire to commit sedition, you conspire to commit treason, you conspire to commit an offense under the Excise and the Custom and Management Act, conspiracy to commit any offense at all has no time limitation. They can try you for that your offense of conspiracy. The fact you conspired, they can try you at any time. They can come 20 years later and say, look, you conspired to murder one or calf or corn, So there is no, the offense of conspiracy is the perfect example of that saying, a crime no the sour. I think the perfect example is the offense of conspiracy. There is no exception. Conspiracy does not abate. They can try you at any time. Also, it's relevant to know that the Public Officers Protection Act does not apply in criminal actions. Under the Public Officers Protection Act, they said any action you're bringing against a public officer in Nigeria must be within 3 months. You understand? So that is only in civil matters. You understand? It does not apply in criminal matter. If a public officer commits an offense, he can be brought to court even if 7 months later, 1 year later, he cannot say, look, I'm a public officer. The Public Officers Protection Act said within 3 months. That applies only in civil, not in criminal matters. So now, how do you institute criminal actions? How to institute criminal actions? That is, how do you commence criminal actions? Understand? How do you commence criminal actions in court? Now, most of the ways you commence criminal actions here are just for the purpose of your bar finance. Understand? In practice, you might find something different. Understand? But you might find something different. It's mostly for the sake of your bar finance. So in the Federal High Court, criminal actions are commenced by way of charge. Understand? Are commenced by way of charge. And then at the National Industrial Court, criminal actions are commenced by way of charge. A magistrate court in the south, that is in Lagos, is also commenced by charge, and the charge is usually signed by the police or by a law officer. And the magistrate court in the FCT, a crime proceedings may be commenced, criminal actions may be commenced either by charge, by complaint, or by first information report. At the magistrate court in Kano, criminal action is commenced by charge upon receiving a first information report or by complaint, whether or not on oath. Now, this by charge upon receiving a first information report. We are going to explain it later so you will understand. And then in High Court in Lagos, that is South, criminal actions are commenced by information signed by a law officer on behalf of the Attorney General of the state, which must be served by that law officer. And then High Court in the FCT, criminal actions are commenced by information, which is usually signed by or on behalf of the Attorney General of the Federation by a law officer, that is usually the State Council. And then High Court in Kano North, criminal actions are commenced by charge signed by or on behalf of the Attorney General of the state, by a law officer. And then we ask ourselves, is the consent of the judge still necessary to file a charge or information at the High Court? There was this practice that before you file an information or before you file a charge to prosecute a person at the High Court, you needed the consent of the judge, you understand? You needed the consent of the judge. If you look at the case of Clement Isong against Attorney General of the Federation, I think that was one of the cases. But now that is no longer necessary. You understand? That is no longer necessary. You don't need the consent of the judge again to file any criminal action against any person in court. You might see the case of Abacha against state. So now we look at the procedure for first information reports. We said in the notes one way you can institute an action. We said one way you can institute an action in the magistrate court in the north, magistrate court in Kano or in the north, is by charge upon receiving a first information report. And then now we want to see that procedure. So now, what is the procedure for first information report? Now look at how it happens. Somebody comes to the police and say, look, another person has committed an offense. And then that offense which that other person has committed must be a kind of offense that the police officers can arrest, and then it must be triable by a magistrate within the jurisdiction in which police officers operate. And then if the person is making that complaint orally, police officers will have to reduce it into writing in the police diary. And then if there's any reasonable suspicion as to the commission of that offense, police officers will also note it in their diary. If the police officers believe there is no public interest in prosecuting the case will not in any way be of public interest, they may decline that complaint and then advise the complainant to just prosecute it himself. He should approach the court directly. You understand? But if there's need, in the interest of the public to prosecute that matter, then the police will now go out to investigate the offense and arrest the suspect if necessary. And then if in the course of investigating that suspect, the police now realize that there is no reasonable cause of action, they will have to terminate the whole matter, and then they will update their diary accordingly and write that the person who went to investigate, it turned out that there's no valid case against him. Understand? But if there's a valid case against the person, that complaint is formalized into a first information report, and then the suspect is taken to a magistrate. So you see how we come about first information report. It starts with a complaint. Somebody makes a complaint to the police goes to investigate, and then if the police believe there is no valid cause of action, they will just stop the investigation and then write it down in the police diary. But in the course of the investigation, they find out that yes, there's a prima facie case. The police officers will now formalize that complaint into a first information report. They are the one now that will draft that first information report. and then they will take the suspect to the magistrate court. Now, before the magistrates, if they take the suspect to the magistrate court, before the magistrate, the suspect has two options. The suspect has two options. He can just confess and be convicted, or he will dispute the allegation, and then the magistrate will have to determine if there is really a prima facie case. Understand? And then based on the magistrate findings, the magistrate will now frame a charge and try the person. That is, the magistrate will draft the charge and try the person. Although we'll get to that later when we do charges. In the magistrate court, not it is the magistrate himself that drafts the charge sheet. You understand? Although in the south, it is police officers that draft the charge sheets. So, based on the magistrate findings, the magistrate may frame a charge and try the case. Or he can just transfer the case to another magistrate, or he can refer the case to the high court if it's the appropriate forum, to try the said matter. So in the next class, we'll now look at charges. We look at charges. Charges is like the most important. It's like the most important topic as long as law school is concerned, because it's usually number one question, and it's about 20 marks, or some years they will make it 25 marks, depending. So it's very important. People usually complain about charges. Oh, charges is this, is hard. It's not hard, you understand? So once you get to charges, and then you see how well arranged it is in my notes and explanations, you definitely understand your charges very, very well.